Hello everyone, I'm Ankit and you're watching the StudyIQ IS English channel. Now we are in a process of discussing important Supreme Court judgment, and in our today's video we are going to discuss a very important Supreme Court judgment, that is the judgment given by the Apex Court in the A.K. Gopalan versus State of Madras in 1950. Now the context of this case began much before 1950. As the person in question, Mr. A.K. Gopalan, he was a very famous communist leader of India who earlier belonged to Indian National Congress. But eventually, at the time when India was fighting for its freedom, Mr. A.K. Gopalan decided to join Communist Party of India. And as a result of his activities, the colonial government, that is the British government of the time, decided to put him in jail. Now let us come back to the date India got independent, that was 15th of August 1947. And naturally, like every other Indian citizen back then, Mr. A.K. Gopalan was also very excited. He had decided to celebrate India getting independence by hoisting a flag and giving a speech while being inside the jail. Now barely 4 or 5 minutes into his speech was interrupted by jail authorities, and later on he was even charged by spreading disaffection against the then Her Majesty's government, that was the government of colonial rule, and this was actually the charge of sedition. Now after India became a republic in 1950, since enactment of its constitution, Indian government came up with a new legislation to deal with matters of preventive detention. That was Preventive Detention Act 1950. And under this act, government wanted to regularize the process of detentions, which included detentions of many individuals, including Mr. A.K. Gopalan. Now Mr. A.K. Gopalan, he thought that since India became an independent country with a constitution for itself, there are many freedom which are guaranteed under the Indian constitution. And as per those freedom guaranteed under the Indian constitution, Mr. A.K. Gopalan moved to the Supreme Court of India, highlighting that the freedoms which are guaranteed under Indian constitution, particularly Article 19 and 21, they provided for his detention to be called as illegal detention, and hence the case which emerged out of this challenge into the Supreme Court went on to become A.K. Gopalan versus State of Madras case. Now to understand this case, we have to understand what are actual freedom and guarantees that are provided by the Indian constitution that, according to A.K. Gopalan, made his preventive detention an unconstitutional and an invalid detention. First article in this regard is called as Article 19. And if you remember your polity class, you'll be sure knowing that Article 19, it guarantees citizens of India the right of freedom of speech and expression, and also to move freely within India itself. Now there are many different types of rights which are available under the ambit of Article 19, which includes freedom of speech and expression, freedom to form assembly, freedom to form associations, union or cooperative societies, freedom of movement, freedom to reside and settle, and freedom to undertake any profession. And particularly the most important freedom for the perspective of our today's discussion is freedom which is provided under Article 19, subsection 1, subsection D of the Indian Constitution, that provides citizens of India freedom to move within the Indian territory. And according to Mr. A.K. Gopalan, this very provision of the Indian Constitution, it made his preventive detention illegal and unconstitutional. Also, if you look at Article 21 of the Indian Constitution, it states in verbatim that no person shall be deprived of his life or personal liberty except according to the procedure established by law. And as this article in verbatim provides that no person should be deprived of his personal liberty, then according to A.K. Gopalan, the main issue was that Preventive Detention Act of 1950, as per Article 21 of the Indian Constitution, it was arbitrary and it violated the principles of natural justice. Now, what is principles of natural justice? You understand there are many principles that are anchored as a very just principle. For example, if you are arresting any person, you should be giving that person an opportunity to put his case forward in a court of law. Also, while giving judgment in any case, the authority should provide the reason for that judgment. And also this entire process of jurisdiction and justice delivery system should be free and transparent in nature. So this is what principles of natural justice is all about. Whereas on the other hand, A.K. Gopalan highlighted that since his detention did not provided him with opportunity to put his case forward, or this entire process was not actually transparent process, hence it violated his principles of natural justice. And A.K. Gopalan wanted the courts itself to interpret Article 21 in a broader framework, that not just a law which is passed by the parliament, it becomes just because it followed a certain procedure, but it also needs to be fair and transparent so as to ensure the principles of natural justice of the detainees. So this was the background of this case, that A.K. Gopalan put forward his case citing Article 19 and Article 21. Article 19 allowed people to move freely within India, whereas Article 21, it said that you can't deny any person his personal liberty, especially when you do not take care of his or her principles of natural justice. But if you read Article 22 of the Indian Constitution properly, you will see that Article 22 indeed provides sections of people protection against arrest and even detention, which includes certain measures like right to be informed of the charges that are levied on a person, right to seek a help of a legal professional or a lawyer, and right to be produced before a court of law in 24 hours since the time you have been arrested. But if you look at Article 21 even more closely, you'll look that there is a strategic exception also provided in this very article. That is Article 22, it provides that protection is that are extended under Article 22 otherwise, that is right to be informed of charges, right to seek a help of lawyer, and right to be produced before a court of law. These are suspended when arrest is made for a person according to the law, which is specifically provides for preventive detention. And if you look at the laws which are used to provide for preventive detention to criminals in India, which includes right of Preventive Detention Act, it was passed well under this strategic exception of the Article 22 of the COI. So this was what the case was all about. Now in front of the Indian court, that is the Supreme Court, there were two particular questions that aroused in this case. First was whether to interpret Article 21 narrowly or broadly. If you interpret Article 21 narrowly, it means that any law which is passed by the parliament of the country, if it is passed by adhering to certain procedures, then that law itself becomes valid. But if you broadly interpret the Article 21 of the Constitution, it does not necessarily mean that the law has to follow a certain procedure, but in addition to that, that law also should adhere to principles of natural justice. And if that two cases are not satisfied, then according to Article 21, if you read it broadly, that particular act becomes unconstitutional or invalid. And A.K. Gopalan, he also argued that personal liberty was defined narrowly as per the interpretation of the government, which restricted the physical freedom of a person. And he also restricted or highlighted that the restrictive scope of Article 21 of the Indian Constitution is actually what is keeping him inside the jail. So this was the two interpretations that were to be decided by this court in this particular case. And what did court actually decide? Let us try to understand this. Now, if you look at the judgment which was passed by Supreme Court of India on May the 19th, 1950, you'll realize that the 6th judge bench of the Supreme Court, it actually held that preventive detention law which was passed by Indian Parliament in 1950 was actually a valid law. And why was it actually a valid law? Because it was passed by the Indian Parliament adhering to certain procedures, which is provided under Article 21. While doing so, it allowed certain minor procedural safeguards to be allowed to the detainees of the Preventive Detention Act. That is, the length of detention has to be informed at the time of arrest, although it can be extended after that. Now, the Supreme Court, it also highlighted or it interpreted the Article 91 of the Indian Constitution and stated that in Article 19 of the Indian Constitution, which provided right to move freely inside the country, it was only available to free person and not the persons who are detained under an act of law. And hence, according to the Supreme Court of India, the Article 91, it cannot be claimed as an exemption to people who are under the detention or who are under the jails, as it is only available to free persons. Whereas on the other hand, the Supreme Court of India held that the procedure established by law, which is actually provided in the Article 21, it is to be interpreted quite narrowly. Which means if the law, it is passed by the parliament adhering to certain procedures, then the law itself is valid. And the law of parliament does not have to satisfy with the broader interpretations of Article 21, that it not just be fair, or it shouldn't even qualify the needs of principles of natural justice. And the majority opinion of the Supreme Court, it held that the law is a sense of law which is made by the state itself, and it should not sense or it should not fulfill the broader aspects of principles of natural justice. Understood? So this was the interpretation of the Supreme Court in the A.K. Gopalan judgment of 1950. That first of all, the protection of Article 19, it is not available to people who are under the jail right now. It is only available to people who are free. Whereas Article 21, that is procedure established by law, should be interpreted narrowly, which means the law which is passed by the parliament, if it adheres to certain procedure, then that law is valid. Whereas on the other hand, the Supreme Court of India, it stated that the law passed by parliament does not have to satisfy the broader interpretation of Article 21, that is satisfying the need of free, fair, or even satisfying the need of adhering to principles of natural justice. Now, what is the implication or the long-term implication of this ruling? Does this ruling continue even today, or does the Supreme Court has changed the very foundation of this ruling? And in this regard, I'll be happy to tell you that Justice Fazl Ali, he actually gave a dissent in this very judgment of A.K. Gopal case. And in this judgment, Justice Fazl Ali, he stated that the question of whether a law means nothing more than a statute law should be interpreted widely. That if you look at the dissent penned by Justice Fazl Ali, he actually highlighted that you need to interpret Article 21 broadly and not narrowly. That the law passed by the Indian Parliament should not just fulfill a certain procedure, but should also satisfy the broader needs of fairness, justice, and also should adhere to principles of natural justice. And the judgment or the dissent of Fazl Ali in the A.K. Gopalan judgment, it stood vindicated when Supreme Court of India in Menka Gandhi versus Union of India case highlighted the need to follow due process of law as against just merely adhering to the procedure established by law. That any law which is to be passed by parliament has to be fair, has to be transparent, and has also to satisfy the principles of natural justice. So this was all for today's discussion on the A.K. Gopalan case. Please stay tuned to our YouTube channel for more such informative videos on the important Supreme Court judgments.